Okay, let's get started. Once again, welcome and thanks for joining today's session, Utilizing ProbateCash to Serve Your Clients and Build Your Business, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. Mark will address questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat, and someone will respond separately after this presentation. Our presenter today is a professional with extensive experience in the probate field. Mark Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Mark is also a member of the Florida Bar's Real Property, Probate, and Trust Law section. Mark has been working in the specialty finance industry for over 25 years and involved in purchasing of over $100 million worth of assets. Most of his purchases, pursuant to various state laws, require court hearings, many of which Mark has either attended or appeared as counsel. As the CEO of ProbateCash, Mark is now spearheading a relatively new industry of purchasing interest in actively pending inheritance claims from estates or trusts. So now, without further ado, let's hear from Mark. Mark, can you start us off with telling us what ProbateCash does?
Yeah, thanks, Molly. Good afternoon to everyone. I do a lot of these webinars with the help of Molly and others, and can tell you that it's great to have lawyers as our primary audience today from around the country. You guys are the folks who really are on the ground floor and understand the needs of beneficiaries of estates and the probate process, and that's what Probate Cash here helps to hopefully make your job easier. So, what does Probate Cash do? Probate Cash provides advances to beneficiaries of estates that are waiting for their inheritance that's tied up in the probate courts. So, some background, as Molly said, I spent a lot of my career providing liquidity to people who are entitled to future cash flows. They don't have the ability to access that cash flow for various reasons. So we're here to be able to help them do that. As most everyone on this webinar can attest, and have likely fielded repeated phone calls from clients or beneficiaries of a client, access to an inheritance really falls into that category. So, people unfamiliar with probate probably believe, like most people, what they've seen on TV. They go, someone's passed away, and they go to the lawyer's office. Well, they haven't gone to the lawyer's office. Where do they go when someone's passed away? They go to the bank. They go to the bank account. They go talk to a realtor, and they want to sell the house. And that is when, for the first time, many people learn about the process of probate. When they try to withdraw money from the account, of course, they're told, no, you can't. It belongs to the estate. You don't have the legal authority to take the money out of the account. Same thing with selling a house that belongs to the estate. You can't sell what you don't own. The estate owns the house, not you, potential beneficiary. So the next thing they do is go to their computer and they hit Google and they find law firms and find attorneys to open up the probate case. And then they do that so they can get access to the money, sell the property. At that point, they learn, wow, it's going to take a year. That's even if there's nothing, no issues. So way different than what they've seen on television, right? And so you guys are the ones who hear about it and they don't understand why it takes so long. So that's what we do is we come in and we fill that need. That's that's our void that we fill up. That helps take the pressure off of the personal representative who's fielding calls from the beneficiaries, which in turn takes pressure off of you lawyers. So who are constantly being barraged by phone calls, where's my money, not understanding how long the probate process works.
Okay, but how does an advance from ProbateCash work?
How does it work? Okay, so somebody needs the money. They come and contact us. We talk to the beneficiary, or we can talk with you, the lawyer, even if you're representing the beneficiary, or if you just are interested, you're representing the personal representative of the estate, and you want to help the beneficiaries. We have them complete a simple application form, then tell us a little bit about the estate, and then we can often fund the advance within 1 to 2 business days. We have underwriters who review the case that's filed. If the case hasn't been filed, which we can work on, we'll talk to you and make sure that there's assets that are going to be sold. The goal of the advance is to provide some necessary liquidity to a beneficiary while keeping the beneficiary engaged and seeing the probate case closed. So as such, we do not purchase the entire inheritance. We always want to keep them engaged. Depending on the status of the probate case, we may only purchase a small portion of the inheritance. So for example, if the claims period is not expired or there's litigation, we may provide a more modest advance because we don't know what could be coming down the pipeline as far as claims. If the case is in final distribution and we have a very good picture of what the heir will be receiving, we'll make a larger advance. It all depends on the status of the case and other various factors in our underwriting. But one of the things about our transactions is they're not loans. There's no credit check. They're non-recourse, so that's why our advances would be modest before the claims period. If we get wiped out, or the heir gets wiped out because a large claim comes and is filed against the estate, that means the heir is not going to receive an inheritance or as much of an inheritance and may not be able to repay us. If we can't get repaid, we can't get repaid. From the inheritance, that's kind of that is our business risk. And so there's no recourse to the heir, no recourse to the other beneficiaries.
Okay, so but in regards to our audience today, how can Probate Cash help law firms?
Perfect. So just like beneficiaries need money today, don't want to wait until the inheritance is filed or until the inheritance is received, assets distributed. Law firms can be in that same boat. My wife is a solo practitioner. I know that cash flow is a big deal with law firms, with your employees, everything. So some states have statutory fees for attorneys, but you can still get your costs paid up front from the personal representative, person petitioning the court to be a personal representative. So what we see are attorneys who are marketing and they attract potential clients, but they want a retainer or they want at least cost paid. And the people can't pay it. They just don't have the money, right? The person at the bank said you can't withdraw the money because you don't have letters. Well, they can't get letters unless you file the petition for letters, you open up the probate. What we will do in those situations, so you, attorney, don't have to turn down these cases, is we will advance money to the person petitioning the court to open up the probate to have the letters. We'll advance money to that person for the purpose of that person paying your firm a retainer or cost. Keep the cash flow alive. You can start opening up the case and not be out of pocket to do so. We will do that. We will want to meet with you, make sure that there is a house that's going to be sold. Our firm will make sure that there's equity in that house, and that house, when it's sold, will be the purchase price will flow through the estate and then paid to the beneficiaries. The estate can record that as an expense against the estate. And so it'll be shared among the different beneficiaries. But meanwhile, you're getting paid up front. And then, of course, that starts the whole court process. And the other beneficiaries who may need money for whatever need, personal living, to help sell the house, the estate home. A lot of times the estate home needs repairs to get fair market value. A lot of times the house is in arrears for taxes, and that needs to be paid. Those are many of the purposes why we provide these advances. And that helps not just the beneficiaries, but this is how it can help you retain clients that you may otherwise turn away because of those potential clients' inability to pay upfront cost or retainer.
Well, I see how that would be beneficial. But now, are there any laws that govern inheritance advances?
There are actually, but not many. Only one state has a law on inheritance assignments. And so those assignments, that's in California. So all my California lawyers out there, there's a California law in the probate section, probably have a section somewhere. It's, oh my gosh. Oh, we have the probate section. I'll get that for you probably before the end of this call. But there is a probate section in California that governs inheritance assignments. But I can tell you how it works easily. It works, and it's important if you're not from California because we follow the spirit and letter of the statute in other states we do business. We file the assignment of the inheritance signed by the beneficiary who's receiving the inheritance with the court. And that says I'm assigning, for instance, $20,000 of my inheritance to ProbateCash, and directs the personal representative to pay ProbateCash from the distribution of the assets at that time. That's then filed with the court. We're paid by the personal representative pursuant to those instructions and pursuant in California, pursuant to the order, which would include probate cash as a payee in the final distribution. So the other states across the country we do business in, but there is not a statute in those cases. But we follow the California statute just like that. And I'll give you that statute.
Now, you mentioned a few minutes ago that probate cash can actually fund deals in 1 to 2 days. How can probate cash fund in advance so quickly?
Sure. So, as I said, these aren't loans. So, really important to note, these aren't loans. They aren't loans. All right. So, why is that a big deal? In a loan, there's a loan application. All right. There's collateral that must be obtained. And then, depending upon whether or not it is a good credit risk, then a committee will come by and say, okay, we will approve this person for a loan. That's not what we do. And likewise, in that loan scenario, if the loan is not paid back for any reason, usually the lender will sue the borrower in that case for recovery. So in our business, we do these non-recourse advances I mentioned. So if the heir cannot repay the advance due to an insufficient inheritance, we'll be shortchanged. And that's our risk. We understand that. Those risks could also be if a will is challenged, that's our risk. A creditor wipes out the inheritance, that's our risk. So sometimes we see where a case is filed and it's intestate. And so then that's what's filed the petition with the court. We say it's intestate, or you say it's intestate. And we learn actually that a will has been discovered and has disinherited one of the people who would have been in line for an inheritance intestate. Well, that's our risk. We will get wiped out in that situation, and we do not go pursue any legal remedies because we have none. It's non-recourse against the beneficiary. The only time that we will pursue a legal remedy against the beneficiary if the beneficiary receives the inheritance but doesn't repay us. So if the personal representative fails to pay us, it goes to the beneficiary. The beneficiary does not pay us. That's just stealing, and we are going to it's a breach of contract, and we will sue. So that's a big difference as well. What are some other differences? We don't charge an interest rate. So there is no interest rate because we don't know when we're going to be paid back. Sometimes our advances are out for 90 days. Sometimes they're out for 3 years. It depends on the probate. They're all different, as you know.
Okay, now how does an advance to one beneficiary affect other beneficiaries who are not assigning portions of their inheritance? So how does that advance affect the probate case, I'm sorry.
Yeah, so that's good, and it's important for the attorneys to know that because you're representing. The last thing you want is for the estate to be held back, or a beneficiary's rights to be adversely affected because another beneficiary has done an advance. Probate cash is only in contract with the beneficiary of the estate who is actually taking an advance from our company. We are not in contract privity with other beneficiaries. We're not in contract privity with you, the attorney, just the beneficiary. If the beneficiary cannot repay us, I said that we have no recourse to that beneficiary. And also we have no recourse, of course, no recourse. We have uh, no legal right, no contract with the other beneficiary. So therefore, a shortfall by the beneficiary who we advanced money to will not affect any of the other beneficiaries, nor will it affect the estate in being delayed in distributing the assets. So there's nothing that'll slow down the probate process because we've done an advance with the beneficiary. In fact, I would only say that it makes life easier for the personal representative and the law firm because we've given an advance to a beneficiary who really needed the money, and that having the money solves a lot of problems. Having some of that money takes the pressure off, and likewise takes the pressure off of the personal representative or your office.
Well, wow. Thank you so much, Mark. We've actually already reached that 15-minute mark. And as promised, Mark, you're going to stay on and answer anybody's questions. But if you need to leave now, we're going to send everyone a link to this recording and the presentation and the questions and answers. But let's get to everyone's questions. Let's see. The first one I have here is, as an attorney for an estate, can I be held responsible if I talk to your company about an advance or if you don't get repaid?
No. Well, I guess there could be a way if we had a contract documents signed in that sense, but we don't because I know that you're not going to sign those documents, and I wouldn't ask you to. We want to talk to the attorney for the estate or get referrals from the attorney for the estate, just so we can put everybody on notice that this is what we're doing. We're making the advance. We don't like surprises, and we know you don't like surprises. So if we're going to make an advance to somebody, we want you to know about it. Yes, we file the assignment with the probate court, so you will eventually know about it. But we really want to make sure that a conversation with you before we make the advance. Number one, you may tell us that we should not be making this advance for some reason that you know about that's not in the records yet. We want to hear about that. But at the end of the day, we're not asking you to guarantee repayment to us. We're not holding anybody legally accountable for any of the answers. We're just trying to get a little bit of information in addition to the underwriting that's in the file, and to just let you know that this is what we're doing.
Okay. Another question we have come in here says, how can I leverage probate cash to sign a client?
So kind of how we were talking about earlier, I have lawyers who are constantly saying no to potential clients because they don't want to be out the cash. They don't have the cash flow at however much, 3,000, 5,000, $10,000, depending on the case and where you are, to put the money out at like on a contingency basis. Uh, you can leverage probate cash to sign a client by number one. You can rely on probate cash in scenarios to front the attorney's fees or cost, so you don't have to. Number two, how do you leverage probate cash? When people come to you, they are saying, I need money right away. The bank won't let me withdraw money from the account. I can't sell the house. And mom and dad passed away, and I have no way to access the cash. Well, you can't you as the attorney can't lend money to them. I don't think. And so, however, if they sign with you, you do have in your toolbox, the Probate Cash is a company that can get them money today. So if a client comes in and says, I just really need money now, let them sign with you, and you're able to refer them. And before the end of the week, in a couple of days, they could have $5,000, $10,000, whatever it may be, in their pocket. Um, that's definitely a valuable tool for you to have as an attorney trying to get clients.
That makes sense. Another question we have here is, what are the downsides of taking an advance from probate cash?
So that's a really good question, and I'm an attorney. I've had clients in my past lives. I want to make sure they understand the pros and cons, and I think that these kind of advances are not for everybody. We charge fees of 25% of the advance amount. That's starting at 25% of the advance amount, and those fees can go up. That is a high fee. Those fees actually reflect our risk. Oh, yeah, we are at risk of claims or other challenges, or just very lengthy delays, even when there's nothing going in, nothing adverse with the probate. So that is something definitely for people to consider. I believe that if a beneficiary of an estate waiting for their inheritance needs money today, they should look at their options before coming to us. They should see if there's a less expensive way to raise money if they have friends or family. Now, one reason people come to us even who could get a better rate or fee than coming to probate cash is that even if they do have collateral, even if they could qualify for a loan, the loan can take weeks before you get the money, whereas probate cash can pay in 1 to 2 business days. So, like any lawyer, I like to caution that everybody understand their options before we before we fund somebody in advance. We admonish that person that they should talk over the advance with counsel, or at least know they have the opportunity to consult with counsel. Before we pay them the money, we actually do a recorded call with our beneficiary to make sure that they understand the terms that are in the contract. And our contracts are actually not so much legalese. We have our contracts in everyday layman's language. So we try to keep this process as simple as possible.
Okay, that makes sense. And we have another question here. It says, can I advertise that I'm working with Probate Cash? Meaning, can I advertise that we have an option to pay our firm's retainers?
So that's a good question. I would say if that is something of interest, I'm always going to hand out my information, and you should certainly contact me. We have a great marketing team, and there's been instances where people will put our logo on their signs. Certainly, with that kind of situation, we want to make sure that anybody that is coming to you, if there is some relationship, understands there's that relationship. And as long as clients are aware of it, I think already it's very important. It's a good resource to have us, just to help you retain or attract clients who may need money.
Awesome. I'm going to pop over and make sure we got to everyone's questions because that looked like the final one we had. I think we got to everybody's. Now, as you said, I'm going to give out your contact information here. We will be sending up a follow-up email with an e-brochure about Probate Cash and a link to this webinar. But right now, I'd like to give Mark's contact information, so get your pens ready. You can call Mark at 561-476-0018, or you can email him at mark, and that's MARC, at probatecash.com. Thank you for all the questions, and thank you for joining us today. Have a great day.
Thanks, everyone. Thanks, Molly.